let's move to our next speaker, Advocate Anil Kamble sir. He is a practicing advocate for last 20 years. He is a special public prosecutor in the Honorable Bombay High Court for caste atrocity matters. He is a public-spirited person to fight caste atrocities and actively represents the victims of caste atrocities in the session courts and other courts as well. We are honored to have you, sir.
Thank you.
Thank you. Now I request sir to address the gathering.
Good afternoon, friends.
Good afternoon, sir.
I am here to learn something from you, not to teach you something. Okay? Firstly, keep in mind I am here to learn something from you. Or otherwise we can say we will learn with each other. A topic given to me is scheduled caste and scheduled tribe, prevention of atrocities. Firstly, we will understood what is atrocity. What is atrocity? Kinds of atrocity.
Discrimination.
Discrimination. Right? Sorry? Verbal abuse.
Untouchability. Untouchability.
Untouchability. Next. See, you are right. These are the kinds of atrocity. But we can make some parts of atrocity. See, we can part in 6 topics. Firstly, what is atrocity? Atyachar. Literal meaning is atyachar. Somebody slaps you, it is atrocity. Right? Then why a special act is enacted in 1989? Just my learned friend stated that untouchability is an atrocity. All we know that on 26th of November 1949, we adopted our constitution, which came into force on 26th of January 1950, wherein some of the basic human rights are enshrined. All you have studied Article 17, untouchability. When a specific Article 17 on the topic of untouchability was enacted in the Constitution, then why the legislature find it necessary to enact a special act, that too after 39 years of independence? The Scheduled Caste and Scheduled Tribe Prevention of Atrocities Act came into force in the year 1989. We have adopted the Constitution in the year 1950. What was the necessity? Can somebody answer this question? See, Constitution is supreme. All we know. Constitution is supreme over all other laws. If an enactment is there, a supreme enactment is there, then why Atrocity Act came into force in 1989?
Overcome what happened before the Constitution, upheld them.
Before the Constitution?
No. Whatever happened before Constitution, to overcome that, to uphold them, to give a helping hand to that society or that community.
So, go in detail about the rules, regulations and other.
Little bit loudly.
So, go in detail about the rules, regulations and punishments.
Alright.
What is mentioned in the Constitution?
This side.
So the community was marginalized from ages because of the caste system, and to make sure that they are not continuing with the same pattern, because untouchability on its own is just one broad spectrum, to also specify all the other atrocities under the act.
Even after enactment of and adopting of the Indian Constitution and untouchably under Article 17, the scenario in the society was that the acts of atrocities were continuous towards a specific sector of the society, that is scheduled caste and scheduled tribes. You must have learned in the Constitution, the scheduled caste is Act Civil number 35, Scheduled Tribe, then Article 340, 341, special enactment is there, a special provision is there. So the acts of the so-called higher community in the India were not stopped even after the constitution. Therefore, in the year 1989, a special law came into force. Now, you all know the title of the act is the Scheduled Caste and Scheduled Tribe, in bracket, Prevention of Atrocities. So what do you mean by prevention? To prevent somebody, to prevent the culprit, to prevent the wrongdoer. But even today, after this enactment, whether the atrocities, the acts of atrocities are stopped across the India?
No.
What is the report of NCRB 2021? According to the NCRB report 2021, the act of atrocities were enhanced but not reduced. Even after this enactment came into force in 1989, 11 years and this 33 years, the acts of atrocities are not controlled. See, in my personal opinion, being a practitioner, the title of the act itself is defective. What is the title? The prevention of. So is there any prevention? A person comes, slaps a person or abuses a person in his caste. Suppose take an example of A, abuses B on his caste. The wrong act has been done by him. What is the remedy available to B? To go before the police station, register the FIR, the police will arrest him, he will commit him to the court will try him for the offence, and thereafter, if found guilty, the court will punish him. Where is the prevention? He has done his act. The court will take number of years to conclude the trial. So am I wrong or right to say that the title of the act is wrong?
Yes.
It is defective?
Yes.
Where is the prevention? So who will ask this question to the Legislative Assembly to correct the name? Anybody will dare to write a letter to Law Minister? No one will. Can try. So prevention is a different thing and protection is a different thing. So in my opinion, the title of the act should be Protection of Atrocities. For example, in the year 2005, a special enactment is there for the protection of women from domestic violence act. It is not there in your syllabus, but that enactment is special for the women. So coming to our topic, the kinds of atrocities based on caste, based on religion, based on race, based on gender, and lastly based on color. So in India we will found the atrocities based on caste, race, religion, and based on gender. And the atrocities based on color, it is there in South Africa and foreign countries. So the first topic, atrocities based on caste. In the enactment, section 3 is given, an elaborate definition of atrocity is given. I have gone through and studies, and day by day I am learning definitions of many words. But in this special act, the meaning of atrocity which is given in section 3 is very vast. It speaks whoever not being a member of scheduled caste or not being a member of scheduled tribe does any act. After this wording, the acts are given. 31A A to B, C, D, E, F up till Z. Then again Z1, Z2, Z3, Z, A, B, C. A vast definition is given. It can't be by heart. We will go through it from the barrack itself. But the thing is that our legislature is not working on prevention, only working on protection. And you know, for the protection, police machinery is given, and thereafter law and judiciary is there, the courts are there. But the percentage of conviction under this special act is very low. It is only 3%. If 100 cases of atrocities are registered at a particular police station, the police station never sends a charge sheet. Charge sheet means a final report against that accused for the offence which he has committed. It is called as a final report according to section 173 of CRPC. You have studied CRPC? Criminal Procedure Code. I think ma'am, it is in 5th year, last year of the 5 years ago. Criminal Procedure Code section 173 provides for a final report form. Usually in practice it is called a charge sheet. So the police collects all the evidence, documentary evidence and types of evidence, and it becomes a charge sheet which the police is under obligation to send it to the court. Thereafter the court asks the culprit, that is the accused, whether you plead guilty or not. If he pleads not guilty, then the matter goes on. So this is about trial of the accused, where the prevention is not there, but trying the accused for the specific offence, whether it amounts to protection or whether it amounts to justice. Justice is not defined anywhere in any enactment. You will not find a specific word or a definition of justice, and nobody can define it. According to me, nobody can define it. The eminent juries are there, but nobody can define justice. So I was on the point of trial, whether it is a protection or prevention. What you say? Protection.
Either protection or prevention.
It is neither protection
Or prevention.
nor prevention. Trying an offender in the court, it can't be a protection or it can't be a prevention. But even though the law is there to deter other persons by taking the example of that accused. If an accused is convicted for the offence and it is highlighted in the media, the other persons will take a lesson from his trial that such kind of act is punishable and the court may punish him with whatever punishment provided in that act. So it can deter a person, deter other person from doing a wrong act. Secondly, this is a special enactment. So again, neither for the protection, neither for the prevention, a special court is established under this law. Exclusive special court which will try only the offences under this act. The judge is empowered to only try the offences under this act. Thereafter, in this special enactment, special rights are given to the victims and witnesses. In the Constitution of India, human rights are already given. But being a special enactment, under section 15 subsection A, certain rights are given to the victims as well as witnesses. There are total 13 to 14 special rights are given. Firstly, this right is given in the criminal procedure also, to have the copy of FIR after registering the FIR. Secondly, to know the progress of investigation when the matter is under investigation with the police. Thirdly, to have the access with all the documents, evidences collected by the investigation officer. Thirdly, to have the travelling expenses to the police station, to the court. Disturbance? So certain rights are given to the victims and witnesses under this act, and special courts are also enacted to try the offences under the Atrocities Act. In the year 1955, the Protection of Civil Rights Act was also there. It is a very small act having only 13 to 14 sections. Thereafter, in the year 1989, this special act was enacted having only 23 sections. It's a very small act comparing to the actual acts which are done by the upper communities against the downtrodden communities. The special act is very small, and in my eyesight, it's a failure of law and judiciary to protect the human rights enshrined in the Indian Constitution. Though the judiciary has given a special court and special rights to the victims and witnesses. Again, the rules 1989, SC/ST rules 1989 provides a special choice to the victim of atrocity to have a lawyer of his choice, to have a public prosecutor, that is a special public prosecutor of his choice. In the other courts who are trying for the offences under the Narcotic Drugs, Psychotropic Substances Act or Indian Penal Code Act, for the purpose of trial of the accused, on behalf of the original complainant, a public prosecutor is there appointed by the government after due process. But in this special act, the victim of the atrocity can ask the government, that is the law and judiciary or the district magistrate of that district, to have a special public prosecutor of his choice. He has to make an application before the district magistrate under rule sub-rule 5 that I want Mr. So and so advocate to prosecute my case against the accused in this special court. This special provision is there only in this special act. Other special acts are there, but such type of provisions are not there in other special acts. Any questions from your side? This act is very short. Only section 23s are there, and I'm not here to teach you the bare act. You can go through it. Any questions? I will share my some experience of cases.
Yes.
See,
In nomadic tribes को नहीं apply.
pardon?
Nomadic tribes and other.
No. It is only for scheduled caste and scheduled tribes. The definition under section 3 is very clear. Whoever not being a member of scheduled caste or scheduled tribe. It means other than scheduled caste and scheduled tribe can be the accused. But if a person belonging to a scheduled caste abuses a person belonging to a scheduled tribe, that act is not covered under this act. That act is not covered under this act. Another provision in this act is very special. You might have heard that sometimes police doesn't take cognizance of the complaint.
So if that person is a Dalit, they have to.
No. Even under other laws also, if you will go to the police station, he will not listen to you on very first day or very first minute. He will ask you to come another day. I am busy. So under this special act, section 4 is given, which speaks about punishment for dereliction of duties. If the investigation officer refuses to register your complaint, he is liable to prosecute under section 4. A special law is there, special provisions are there. But even though there is a practical failure, I will share one experience. In the year 2008, midday newspaper is there, you must know. Jigna Vora, when Jigna Vora was the person working for that midday paper. So against Jigna Vora and the retired IG of Maharashtra, Inspector General of Police, one private case was filed before the Girgaon Metropolitan Magistrate Court. In that case, the complainant never turned to the court. The court had taken cognizance, issued summons, notice to the accused appear. They have taken their bail from the court, and thereafter complainant never turned to the court. But it is the duty of accused to remain present on each and every date. Otherwise, the court issues a bailable warrant or a non-bailable warrant against the accused. Even though the court can issue a warrant against complainant also. So in this case, after a gap of 2 years, the complainant turned to the court. He has deposed his chief examination before the court, and he was under cross-examination. Half of the cross-examination was over, and it was deferred due to the recess of the court, and matter was adjourned to some another day. And thereafter, the complainant again for 1 year remained absent, and ultimately, under the CRPC, a special provision is there under section 256. The matter was dismissed in default. So those two persons were accused, Jigna Vora and the retired IG. The retired IG was from scheduled caste. So the complainant make him to suffer for 4 years in the court. So in this special legislation, section 3, subsection 1, subclause P and subclause Q is there, that whoever not being a member of scheduled caste and scheduled tribe files any false, vexatious, malicious litigation against the member of scheduled caste and scheduled tribe, he is punishable under this section. So the IG registered a FIR with MRMR police station against the complainant. The complainant was called to the police station to give his statement. Again, he never turned to the police station. Thereafter, the investigation officer come to the conclusion that a false FIR is registered by the IG. No case is made out. So he filed a summary report. Just I have told you about the final report under section 173. There are types of final reports: A, B, C and D summary. I do not remember the name, but the case was from Alibag. That one interior designer engineer hanged himself, and the accused was the well-known. आप न्यूज़ देखते हो ना, वो बोलता है भारत, पूछता है भारत वाला कौन है? अर्नब गोस्वामी के केस में वो इन्वेस्टिगेशन ऑफिसर ने सी समरी रिपोर्ट फाइल कर दिया, दैट नो केस इज मेड आउट अगेंस्ट अर्नब गोस्वामी, जिसके लिए सुप्रीम कोर्ट ने 2.5 बजे बेल दे दिया था ना उसको. सो द सी समरी रिपोर्ट वाज फाइल्ड इन द केस ऑफ दिस आईजी. सो फॉर एवरी कंप्लेनेंट there is a provision that he can contest his own case. IG went before the court, he contested the C summary report. Ultimately, that report was rejected by the court, and investigation was transferred to another investigation officer. That another investigation officer prepared a final report and formed his opinion that a case is made out. Again, he sent a notice to the accused to come to the court. I am going to file a charge sheet, that is final report against you. The moment accused received the notice, he went before the High Court. CRPC you have not studied, but section 482 of CRPC is there, which gives inherent powers to the High Court. So under the inherent powers, the accused went before the High Court that the first investigation officer said no case is made out. Second investigation officer says a case is made out. The Honorable Court to decide whether a case is made out or not against me. 3 years went before the High Court. Thereafter, third investigation officer came into picture. He formed his opinion that a case under atrocity is not made out. See, the section is very much clear. Again, I will tell you. Whoever not being a member of scheduled caste and scheduled tribes files a false, vexatious and malicious case against a member of scheduled caste is liable for punishment. The complainant in the case made the accused, that IG, to remain present before the magistrate for 4 years. उसने तो अपना 4 साल कोर्ट के सामने बर्बाद किया. So it was a vexatious, malicious litigation, right? A very clear definition is there. Even though first investigation officer formed an opinion that case is not made out, second investigation officer formed his opinion a case is made out, then again third investigation officer came into picture. He formed his opinion and said that I am going to file a closure report under C summary that no case is made out. So the High Court says case is open for both the parties, to the complainant and to the accused, to go and fight before the trial court. Once the C summary report was rejected by the court, investigation was transferred to second IO. Again third investigation officer is going to file a same report which is already rejected. 9 years went in. And who was the complainant? Don't forget. The Inspector General of Police, Maharashtra. He was the complainant. Can you imagine what will happen to a layman? Whether he will get a justice? Till today the case is pending before the special court, wherein the IG is complainant. Now he is 82 years old. Not a single day the accused has attended the court. Now can you say this is a prevention of atrocity? Or is this a protection of atrocity? After 9 years, when the report filed before the special court, the complainant again filed his protest application, which was allowed. The report second time was rejected by the court. The court directly taken the cognizance and issued a summons to the accused. Under section 204, you will learn in CRPC, issued a summons of appearance before the court. The moment the accused received the summons, he again went before the High Court and filed a writ petition under section 482 for quashing of issue process. Anybody from you is working under any advocate as an intern? You must be knowing what is issue process and summons and warrant and all those things. So the matter is pending before the High Court now for whether the issuance of process under section 204 is right or wrong. And the complainant वो चक्कर काट रहा है कोर्ट के. Accused is abscond. His lawyer is representing him before the High Court. So, isn't it a mockery of justice? But see, ऐसा ना हो कि आप लोग सब निगेटिव हो जाओ. आप सबको प्रोफेशन में आना है. You have to fight for the. Somebody will go in civil side, somebody will go in criminal side, somebody will specially work for women's or specially for human rights and all that. So don't get negative. It's a noble profession. You will enjoy each and every minute in the court. You will experience a lot of things which are not taught in the college. So this is my experience about this present time. Any question? Please.
So, talking about the example about the case that you just gave, you just specified that some section 3 something is written that if a person has filed a false case against the person. But sir, don't you think in this case, if you take into consideration menstrual, that is the mental intention, it was not only filed against him, it was also filed against some Priyanka Vora. She was not from the same caste or from the same community. So
if I am not wrong, you want to say that there was no intention of the complainant.
No, sir. I mean, taking into consideration this there was no intention of that caste, that this thing. You know, he wanted to make this case only because he belonged to a certain caste or tribe.
So as all you know that this is a special enactment, section 8 is there, which speaks about the presumption.
No, sir, I'm not aware, sir. Absolutely.
I will tell you. You are aware about the title of the Act, the Protection Prevention of Atrocities Act. Section 8 speaks about the presumption. An accused cannot take a stand that I was not knowing that the person was belonging to scheduled caste or scheduled tribe.
Isn't it a discrimination with other castes? It's been privileged, not privileged, getting reservation, and they are having such another act itself. So what about the other caste also? They are also deprived in deprived society. They are also below the basic
Yes, sir. Like
necessities.
in
So
the
what
same
about
case, that
them?
Bora person, even she had to attend for 4 years. What special this can she ask for here? This person could ask because he belonged to this specific community or something.
See,
Judging someone on the caste basis, isn't it casteist?
but you must be knowing that still in India, there are so many acts and deeds, the acts committed by the so-called upper caste against the scheduled caste and scheduled tribe persons. Therefore, the special enactment is there.
No, sir, but we also
Unless and until the acts of such peoples will stop, the act will remain in force. You can say it a privilege, but it is the legislature find it necessary to enact this special act.
No, sir, I actually want to make my point here. I don't mean there should not be a special act, but taking into consideration every case has different circumstances, right?
Yes.
So this case, maybe, I'm not sure, I'm not aware of the facts of the case, of course, but what I got to know about whatever you said, this can be a perspective, right, sir?
Right. Any more question? No questions? May I sum up or share some more experience?
Experience. So where is the highest rate of?
See, I have shared my experience which was based on a caste discrimination. Now, I will share my experience on a specific word, that is only atrocity, not a caste based atrocity, only atrocities. I am handling that matter which is pending before the High Court. One engineer was there in Air India. In the year 2014, he joined Engineers Association Air India. And one day he was late at his work, therefore his superior officer given him a memo that half an hour you are late today, and he was prosecuted for dereliction of his duties. Departmental inquiry was conducted wherein he was found guilty and he was removed from his services. You have studied labor law? The Industrial Disputes Act 1947? So he was removed from services. So after removal from services, under section 33 subsection 2 clause B, a sanction from National Industrial Tribunal is required for such removal. So after removal from services to the present that engineer, an application was preferred by the Air India before the NIT, which is situated at Sion. The application was pending for 10 years. Till then, he was made to sit idle at home. His month's salary was given by the Air India and he was made sit at home. 10 years, the approval was not given by NIT. Afterwards, this fellow went before the High Court that I was removed from services and approval is not given by the NIT. Till date, 10 years are over. I am starving from my bread and butter. So the High Court has given a time limitation to NIT to take decision on or before 31st of December 2013. The incident happened in the year 2004 when he was removed. A time limit was given to National Industrial Tribunal, but in that time limitation also, the National Industrial Tribunal has not taken any decision. Neither the approval application was rejected, neither it was allowed. Again this fellow went before the High Court and made an application for dismissal of the application. So as I said, under section 482, the High Court has vast power. The High Court in its own inherent powers dismissed the application pending before the National Industrial Tribunal. So dismissal means there was no approval for his removal, right? So he must be reinstated, but the Air India refused to reinstate him. He again went before the High Court that Air India refused to reinstate me. Even the approval application is dismissed by this Honorable Court. The High Court said, in our order, there is no speaking that you should be reinstated. We have just dismisses the application pending before the NIT. Again, the Air India, against the order of High Court, went before the Supreme Court by filing special leave petition. The Supreme Court in the year 2016 dismissed the special leave petition filed by the Air India. Again in the year 2017, a review petition was filed by Air India before the Supreme Court. Again that was also dismissed by the Supreme Court, and till date that engineer is not reinstated by the Air India. Now he is 63 years old, retired from his services. So which type of atrocity is this? Your question was good, that why a special legislation is there for the peoples under SC, ST. So this engineer is not under SC, ST. So which type of atrocity is this? Denying a basic human right to have a service, which is enshrined under the Indian Constitution. So there is much work for you in the court. You all are welcome as a practicing advocate. Any question, or should I sum up? No questions? Any general question apart from this special act? All right. Thank you very much.